All right. Hear ye. The state of Michigan is now in session. The Honorable Michael J. Kelly, the Honorable Adrian N. Young, and presiding, the Honorable Thomas C. Cameron. All persons having business herein draw near, give attention, and they shall be heard. God save the United States, state of Michigan, and its honorable court.
Well, good morning, everyone. On behalf of Judge Kelly and Judge Young, I would like to welcome you all to our first day here in Detroit hearing cases. I see that we have a lot of experienced attorneys arguing before us today. You all know the ground rules in terms of how much time you have, so I won't belabor that point. I would ask if you have any cases that involve minor children, please do not use them by name. If you have a client in the courtroom, I'd ask that you at least alert us to the fact that you have a client in the courtroom. I'd appreciate that as well. So I think that's going to cover our housekeeping business. Why don't we call the first case, People of the State of Michigan versus Anderson, 375876.
Good morning, Eric Hinojosa on behalf of the people, P76546. May it please the court.
Can I interrupt for just a moment? I know that you would move for oral argument. I can't recall whether you have 10 minutes or you have the full time. Do you have the full time?
I believe I have the full time.
I think you do
didn't
too.
see anything that suggested otherwise.
Oh, okay. Thank you. Go ahead.
May it please the court. Police officers are called on to make split-second decisions all the time as to the based on the information available to them. Investigate, detain, arrest, use force, don't use force. They are also called on to judge the credibility of information that's put to them and make split-second decisions as to whether to act on that or not act on that. The question in this case is essentially a determination of whether an officer had reasonable suspicion to conduct a traffic stop of a drunk driver based on information provided by a 911 caller and solely that information that was available to that officer at the time that they made the traffic stop. Or in this, as the defendant would urge in this case, and the trial court has held, is an officer's reasonable suspicion to conduct a traffic stop something that we can retroactively invalidate based on information that the officer did not have available to them at the time that they made the stop and truly was not available to this officer until the 911 caller was rigorously cross-examined about 30 days after the stop occurred.
So let's say we all agree with you that the retroactive invalidation part, or I'll just speak for myself. Let's say I agree with you that the retroactive invalidation part doesn't fly under case law, you know, for a whole bunch of reasons under Fourth Amendment. So the question still remains, though, with the content of the 911 call, was that enough to rise to reasonable suspicion without the addition of a traffic violation? I'm sure your answer is yes, but I'm not sure why, if, as everybody established in trial court, the act of consuming alcohol and operating a motor vehicle in and of itself is not a crime.
Well, so I think, and if you'll indulge me for a brief recitation of what happened in that 911 call, we have the caller's identity and her phone number. She says that she's at the Tuscola County Fairgrounds. She says that she saw two men leaving the event and they were intoxicated by her perception. She said she'd watched them consume 6 beers. She told them multiple times not to drink on the property. She gave identifying information, including their physical descriptions, their ages, their helmets, their clothing, license plate numbers, directions of travel, assertion that they still had likely beer in the coolers on their bikes. She'd seen them dump beer cans in the trash. She'd asked them multiple times not to drink at the fairgrounds. So we're not just dealing with, hey, you just had a beer. We're dealing with, at least at that time, an assertion that they've had 6 beers.
Well,
and based
no,
on
that's not so clear either, is it? She doesn't say they each had 6 beers. It might be implied, but I mean, as long as we're picking apart what she says, she said they had 6 beers.
And I
That
think
could be 3 each.
And I think a reasonable interpretation could go either way in that case. But I think when the officer's deciding, do we act or not act based on this information? Do we?
But see, this is the other thing. And I'm sorry to interrupt you, but you know, is the inquiry as far as the officer goes, what was reported to 911 or what 911 dispatched to the officer?
I believe that it was, in this case, substantially the same.
And this is what it said. I've never seen that actual dispatch to know, because there's a big difference.
Because it was, I believe it was radioed out to the officer based on what the information that came out of the
But say
preliminary
it's like the
examination.
telephone game. I mean, it could be, and if not this case, cases down the road, 911 says, I saw them, there were 6 beers that were consumed.
Mhm.
And then the call from 911 to dispatch says, they had a couple of beers, she said. So, I mean, in the officer, the reasonable suspicion seems to me it should be what was dispatched, not what was originally reported. If the officer has no idea what was reported, and we're talking about the officer's good faith.
And I believe, at least again, with what came out at the preliminary examination, the officer endorsed, I basically heard the information that was in this 911 call that was played in court relayed to me by dispatch. That's the way I remember this coming in at the preliminary examination. So the officer has the information that's in the 911 call available to them, and they are acting based on that information. Now, I think that the situation that you're proposing here, Your Honor, it would kind of suggest, would present a difficulty because, officers are allowed to make arrests based on information that they receive over the radio, that they receive from other officers. If we're going to go and pick apart every step of that and what they've received, whether that was an accurate relay of this information, we're going to be in a whole lot of trouble in every case that we have collective knowledge that leads to an arrest, I think. And
Can I get you back to what Judge Young was asking you? There's two parts of this. First is the reliability of the tip.
Right.
And if you find that the tip is reliable, do the police have reasonable suspicion to make the stop?
yes,
What I thought I heard Judge Young say, let's say you win on the first issue, the reliability of the tip, given they identify themselves, given all of the information that is corroborated by the police, the tip is found to be reliable. The next question is, well, did the police have reasonable suspicion to make the stop? And for that, I think you, in my opinion, correctly identified that you don't look at the preliminary examination. That's completely irrelevant.
Mhm.
Instead, you look at the tip itself. Does it have sufficient support to rise to the level to believe that criminal activity might be afoot, right?
Correct.
That's
Yes.
So as I heard the tip said that these 2 men had at least 6 beers. And the part in your summary that you didn't include was that she specifically identified that they were intoxicated, which is a conclusion. And then said it a second time that they were drunk, which is a conclusion.
Correct.
So my question is after you meet the initial threshold of reliability, yes, this tipster is a reliable tipster. How are we as a reviewing court to review the assertions made in that report? Do we take them as being reliable, as being true? And whether, if true, do they rise to the level of reasonable suspicion?
So Judge, I believe to try to answer that question, I think if you look at all of the information provided within context altogether, I think that you can give some weight to her assertion that these individuals appear to be intoxicated, and also, give some credit to her, her conclusions that they appear to be intoxicated to her, because she's explaining why she believes that they are intoxicated based on their level of consumption and everything else that she's seen there. So I think, at that point, the officer knows that these individuals have consumed alcohol, consumed 6 beers, whether we say that's collectively or together, depending on how you interpret the call, consumed this amount of beer. They are now on motorcycles. They are now leaving the venue. She believes them to be drunk based on her personal observations. Does the officer have the ability to then go check at that point? Is there reasonable suspicion? I think that there is. And I think that I think that
the point I was trying to make is, can we second guess a reliable tipster's assertion that the person is drunk and intoxicated? Or because they're reliable, we take them at their word because we've determined in the first prong that they're reliable.
I think that you could second guess them. I don't think that the officer is required to second guess them, or the court is required to second guess them in this circumstance, because the officer is trying to make this on the fly assertion of, what do I do in this case? Do I stop or not? And we're talking about a Terry stop. We're talking about a brief detention in order to dispel or to confirm the suspicions that have arisen as a result of this call. So we're talking about a minimally invasive action. The information is corroborated up to a point, and
So the officer can second guess the information they get, but we as a court cannot, or the trial court cannot second guess the conclusion that these individuals were intoxicated when considering whether it rose to the level of reasonable suspicion. Is that correct?
I think what we're called upon is to ask whether the officers, and I'm trying to answer your question. I'm not trying to evade it. The officer's decision is, do I have sufficient information to make me believe that this person is intoxicated here, and to take this step, to make the Terry stop, to either confirm or dispel my suspicions here. I think the court can second guess that, but I think the court should accord some deference to the officer. And I think the case law around these sorts of stops suggests that there should be some deference accorded here. I think, I think this is not a case where we have, just an officer's decision that is just completely out of left field, that it's unsupported by the tip, that there's no indicia that criminal activity has occurred.
Let me ask the same question Judge Cameron asked you, which is this. So you do the first step, you find out they're reliable, and we know that this caller is reliable because she gave her first and last name. She called 911. She was descriptive. She said it was personal observations. A lot of that's undermined at her preliminary examination, but we take the call as it was given to dispatch. Okay. So once we determine she's reliable, if she calls and says, I'm at the county fairgrounds and two individuals are drunk and they're about to operate motor vehicles, is that enough to be reasonable suspicion just because we've determined her to be reliable? Is her personal conclusion that the individuals are drunk enough to be reasonable suspicion to make a stop?
I think with those limited facts you presented, that would be a much closer case. But in this case, we have an amount of alcohol, the type of alcohol, the information about.
So it's drunk. So it's conclusion that they're drunk plus 6 beers.
Yes.
So
and
if it's conclusion that they're drunk in 1 beer, do you feel that that's different?
I think that if somebody only saw them consume 1 beer, I think that I would have some questions as to why they believe that this individual is drunk. If now they're saying,
but did you see the problem? I mean, where do you draw the line? That's where this additional step comes in, which is in Navarrete, and so far as I can tell, any of the cases, that despite the tip, they have to independently see some sort of traffic infraction. And in this case, the officer followed, not the guy with the long white beard who bolted, but Anderson, followed him for 5 minutes, correct? Saw no erratic driving, nothing that would otherwise, without a tip, lead to a reasonable suspicion that this person is intoxicated, correct? So under the logic we're putting out here, they wouldn't have to follow for 5 minutes. I get a reliable tip, I see the car, I automatically pull them over. Say somebody called up and said, you're drunk, here's the PBT, blow.
So, Judge, let me break down a couple of the assertions that you made there. I don't think that the case law actually requires them to observe bad driving before they stop. I think in Navarrete specifically, the court said in that case had said that the 5 minutes that was observed in that case where there wasn't any sort of traffic infraction was not sufficient to dispel the notion that this person might be intoxicated.
But the report was that this person tried to run me off the road, which is a traffic infraction.
Correct. Yes.
So there is a traffic infraction.
But there wasn't a requirement that the traffic infraction be observed by the officer, and I thought that that's what you had indicated, Judge.
No, I'm just saying a traffic infraction.
Okay.
There was none reported. there was none observed.
Okay. I think that the traffic infraction that is, there's sufficient information to suggest that a traffic infraction has occurred here because we have sufficient information to believe that this person had consumed alcohol to excess, that this caller, based on their personal observation, which, knowing whether somebody is drunk is within the ken of an average citizen, I think. So, I hear that this person has consumed 6 beers, that this person appears to be drunk based on their observation, their consumption of 6 beers. I think that, and that now they are on a motorcycle and leaving the scene. Do I think that that is sufficient information for an officer to act on and to conduct a Terry stop to confirm or dispel whether there is in fact a traffic infraction at that point? Yes, absolutely. And I
They don't
think
have to observe so that the officer basically wasted 5 minutes following this person without pulling them over.
I think that this court has actually addressed that before in Barber Ridge. It said that when a tip alleges erratic and I'm going to quote from it if you'll indulge me here.
Sure.
Tip alleges erratic and possibly drunk driving, a respondent officer faces a stark choice. He can intercept the vehicle immediately to ascertain if the driver is operating under the influence of drugs or alcohol, or he can follow and observe with 3 possible outcomes. The suspect drives without incident for several miles. The suspect drifts harmlessly onto the shoulder, providing corroboration of the tip and probable cause for an arrest, or the suspect veers into oncoming traffic or fails to stop at a light, otherwise causing a sudden and potentially devastating accident. In this case, the officer made the game time call at that point to follow these individuals. I believe if you observe in the body cam, there's not a lot of other traffic around, so maybe she felt it was safe for her to just engage in this observation period to see if she could take it from reasonable suspicion to probable cause, but she didn't see that traffic violation to take us to probable cause. So she decided to make the stop and try to dispel or confirm her reasonable suspicion. If you take away the ability to make that stop, I think you kind of get rid of that entire intermediate step. And I think the case law also talks about this. Get rid of that entire intermediate step of, let's do a Terry stop. Let's see if there's something there to this tip or not before we get to probable cause. If you see the bad driving, you've got probable cause, and that stop is good all day. So I think that's what we're arguing here is you should not take away that kind of intermediate step that allows the officer to confirm or dispel their reasonable suspicion that is created based on the information provided within this 911 call. I think in this case to do so, to say that this was not reasonable suspicion that we should, and it seems like the suggestion here is that we are not going to Monday morning quarterback this decision, the decision of the officer based on the information provided with the preliminary examination transcript. But I think trying to say that reasonable suspicion does not justify a stop here, or there's not reasonable suspicion and no stop was justified here would be a departure from our current case law.
Okay, thank you. We got plenty of time for rebuttal. I'm sorry, any other questions?
No.
I don't have any right now. Thank you.
Morning, William Ogden on behalf of the defendants and the appellee, Mark Anderson. He is in the courtroom with his wife, Karen.
Okay,
Thank you for allowing them in. I'm going to deviate a little, just zoning in on some of the questions here. And I want to follow up on Brother Counsel's reference regarding Trooper Farnham and law enforcement officers who make split-second decision and judge credibility. That's exactly what happened here. As Trooper Farnham elected to exercise roadside discretion to not immediately pull over Mr. Anderson, with each second that went on, that tip became less and less reliable. I think that's the elephant in the room that was overlooked by counsel, that at what point, we can create a hypothetical, should the trooper have followed Mr. Anderson and the bearded man for 20 minutes, 30? At what point do you say, look, the call is nonsense. All Trooper Farnham sees is good driving. On its face, exercise.
In Navarrete, I mean, that's exactly what happened in Navarrete, right? Where the officer followed for 5 minutes, didn't see any bad driving, and nevertheless made the stop.
Correct.
That was 5 minutes. So that didn't undermine at least in Justice Thomas, in the majority's opinion.
Correct.
That did not in any way undermine the reliability of the tip.
And without getting into and I think we can all agree that Shauna Brinkman was wildly inaccurate, that the preliminary exam revealed her testimony to be incredible, but that's not why we're here.
You agree that that's irrelevant?
Correct. And I agree. I would just argue there is an element of hearsay there that is maybe not appropriate here, or if the case gets remanded, it's
Right.
going to
But
be
in terms
brought
of the
up.
reliability of the tip, what
Correct.
happened a month later at a preliminary examination is irrelevant. Would you agree?
I would agree. And I would also agree with Judge Kelly, what was significant in Navarrete, that there was a report of a traffic infraction. Nothing here. It is legal to crack a beer and drive. It is legal to have 2 beers and drive.
Do you think a law enforcement officer has to see bad driving to make the stop?
Based on what? I think
Case
without
law.
Yeah, absolutely. I don't think, if we live in a world where officers can indiscriminately pull people over, I want out of that world.
No, based on a tip, a reliable tip. Assume that this was a reliable tip.
That it's corroborated.
No, that it's legally reliable.
I don't know how an officer knows whoever calls in is reliable, because I would,
Assume for my hypothetical
okay,
that the tip is reliable.
yeah, absolutely. I would agree.
So if the tip is reliable, can the stop be made if an officer doesn't see bad driving?
An investigatory stop could be made. Yes,
Okay.
absolutely.
So you agree
I do.
that under a different set of facts, a police officer can rely on a reliable tip to make a stop, even though the officer doesn't see driving consistent with, or anyone else for that matter, see driving consistent with intoxication.
I don't necessarily agree. That is a case by case basis. That's where Estabrook says it's the totality of the
For example,
circumstances.
in this case, assume that we don't have 6 beers. Assume that it's not 2 people, it's 1. Assume that the tipster says, I saw the person identified consuming 24 beers. He is intoxicated, so she says, and later in her reliable tip, she says he's drunk. So drunk, intoxicated. I personally saw him drink 24 beers. Could that officer 5 minutes later, without seeing any bad driving, make a stop based on reasonable suspicion?
I would say the officer has the authority. I would say it's a sliding scale. It goes back to, at what point, as each second passes, does the officer who has, and I think we all agree, officers have unbridled
You're changing
roadside
my
discretion.
hypothetical.
I am not.
Let
The
me-
short answer is yes, the officer can.
Okay, so 24 beers, 5 minutes after he gets on the motorcycle, the officer could immediately make a traffic stop based on reasonable suspicion. You agree with that?
I would not only agree, I would say the officers more times than not should. Because of that second bite at the apple that Justice Scalia discusses.
But you're talking about a police officer's discretion. I'm talking about as a matter of law, would that police officer have met the standard of reasonable suspicion?
I can't answer that hypothetical
You can't?
because it is always fact specific.
Would it-
Was there a traffic infraction reported at the time?
If I changed it to 40 beers, would that make a difference?
I'm not concerned with the amount of beers. I think Judge Kelly was correct that in Navarrete, they also reported a traffic infraction. There was nothing illegal beyond, I saw someone drinking and they got in the car.
All right. So just so I'm clear, I want to make sure I understand your position. Your position is or is not that a police officer can rely on a reliable tip alone to make a traffic stop, even if there's no bad driving, or you have to have evidence of bad driving to make a stop based on a reliable tip? Which
The
of those
officer
two?
has the discretion to make the stop. But that discretion is
So-
always saddled under
All right.
fact sensitive
If a police
situation.
officer has the discretion to do it, that necessarily presupposes that he has reasonable suspicion to make a stop. Would you agree with that?
I would agree that, but then I would ask, Your Honor, when does that end? That's where I said, if this officer was driving for 20 minutes behind these people with that same information in your hypothetical, at what point does the officer think, you know, that caller is full of it. These people have not done one thing wrong on the road.
So, okay, different set of facts. If the defendant in this case would have, if the tipster, reliable tipster, so let's take that off the table. The reliable tipster told in the 911 call that the defendant had just smoked a marijuana cigarette. That didn't happen here, but just assume for purpose of my hypothetical that that's what happened. All right. Could the officer, based on that reliable tip, make a stop? Because for marijuana or drugs for controlled substances, any amount of active ingredient in your system is illegal. We were not talking about 0.08 or 0.10. Any amount in the system would be illegal. Under those circumstances, could the officer, based on reasonable suspicion, make a traffic stop immediately without seeing bad driving?
Again, it's fact specific, but the direct answer to your question is yes. And it opens the door to what are all the facts? How do you know it's marijuana? Did you smell it? How do you know it's not medically necessary? How is a layperson able to judge the level of intoxication or the level of impairment compared to a state trooper who has special skills that Trooper Farnham testified to, that she had been in training to identify drunk people?
So last hypothetical. Assume that not this defendant, a different person was at a bar and was served 10 drinks and the bartender was under the mistaken belief that this patron was not going to drive a car. In fact, said, "You're not driving, are you?" "No." So 10 martinis.
Okay.
And after having 10 martinis, he pulls out the keys out of his pocket and says, "I got to drive home now." That bartender, very concerned that his patron is going to either kill himself or kill someone else, calls the police and provides so much information about the circumstances that without question, it's a reliable tip. Okay. Identifies himself. So that's off the table, reliability. Could a police officer immediately stop that vehicle without seeing bad driving?
Yeah.
Because he happens to be a career drinker.
Yes, and in essence, you kind of described the People versus Richter case that Judge Kelly was on, docket number 316532, where the bartender called in on defendant Richter, saw him drinking. The key thing, I think, in the holding there, and the stop was upheld and it was immediate, but the language in that opinion says that a suspected drunk driver under surveillance to personally observe suspicious driving, the officer may make an immediate investigatory stop. If we're talking should have, could have, would have here, I think there should be a hard and fast rule. Officers should pull over people right away because, as Justice Thomas said in Navarrete, you don't want to provide a second chance for dangerous conduct that could have disastrous consequences. And brother counsel brought that up. Maybe the road was empty. Maybe there was no one else out there. But shouldn't the trooper also care about the lives of those two cyclists? Should they hit a rock, throw dirt, run into each other? Their lives are important too. I would say if there's going to be policies being made here, there's two things we need to be aware of. One, everyone with a cell phone is now a sheriff's deputy and expert on drunk driving. That's a little bit loose. In theory, I could say I saw Judge Kelly and Judge Cameron tipping him back in court, and if I had your plate number, you could get pulled over. I don't like the idea of that intrusiveness, Judge.
But as far as I can tell, I'm not going to minimize or summarize your argument, but it seems as though the fact that you were taking the most issue with is the 5-minute delay in pulling your client over, because as each minute went by, that reasonable suspicion was degraded.
I would say it's not a delay. When asked directly by myself at the preliminary exam, why did you wait? Why didn't you just pull them over? Trooper Farnham did what Justice Scalia, probably one of the most conservative justices will ever know. She did good police work. She said and testified, I wanted to see driving. And she saw exactly that. And as she saw good driving, that tip became less credible and the Fourth Amendment got enlarged.
I don't want to misrepresent what you're saying. Am I correct that you're saying the longer period of time that good driving is observed, the reasonable suspicion is degraded?
That seems self-evident, no disrespect.
No, I want to understand.
It does, because the hypothetical is 20 minutes, 30.
Right.
Let's say they drove, Trooper Farnham followed them all the way to the Tuscola County line into Lapeer, Oakland.
So if in this case, the officer would have made an immediate stop, no 5 minutes, no 4, 3, 2, immediate stop, would you still be standing here? Would you still?
Absolutely not. There's two situations where this wouldn't even be appealed. We either be having a trial or we reach an agreement with the Tuscola prosecutor's office. In that situation, and I even told my clients in the hall, we wouldn't be arguing here. But the real situation is, if I was representing the bearded man who was the central figure of everything here, And that is the factual thing that is kind of the other elephant in the room, but not this room. It's in the courtroom up in Carroll. So it creates, when you look at Pagano, when you look at Navarrete, and you look at the case law, I know this court isn't a policymaking court, but when you really overlay everything, and I want your honors to consider this, in a world where technology is speeding faster than I'm turning gray, and I shave my head, no offense, your honor, you're going to see quantum computing and AI and things that are going to spin our heads because, as we all learned in law school, the law is slow to adapt to technology. Look at the element of swatting. And I don't know if you're familiar with this, but when someone can call in a fake report that sends a SWAT team to someone's house, no one's going to be filing a false police charges against a VPN number that's traced through the Ukraine. Law enforcement is not going to chase that down. More importantly,
Okay, before we go too far down this path, I want to go back to reasonable suspicion. So let's say under the state of case law, because she called 911, she gave her first and last name, she indicated personal observation, understanding her preliminary exam undermines almost all of that except her first and last name. But taken at the time of the call, it seems she meets the requirements for reliability under case law.
I think there's a prima facie
Okay.
agreement there. That is the basic, that's the cover charge for entry.
Yep. And then the second part is, well, did the officer have reasonable suspicion? And we really have two elements. So we have some elements that get at reliability, which is like her observations, first and last name, calling 911, those things. And then we have other pieces of the call that talk about reasonable suspicion of intoxicated driving. And there's two conclusory statements. These people are intoxicated, these people are drunk. And then there's the personal observation that between two individuals, 6 beers were consumed. To Judge Kelly's point, it doesn't say each, it just has 6 beers.
Right.
Okay. So before the officer makes this stop at all, does the officer with the 6 beers plus 2 conclusions, intoxicated and drunk, have a reasonable suspicion that the individuals on the Harleys are drunk driving?
Yes, she was fed that information from 911, and that we go right back to police officers' discretion. I can't pretend to know what goes through their minds when you're out in the wild, so to speak, and having to deal with walking up on a car.
So as a matter of law, the content of the call, 6 beers plus 2 conclusions, 1, they're intoxicated, 2, they're drunk, is enough to meet the legal standard of reasonable suspicion.
Assuming the stop is effectuated immediately. I am arguing that just look at Trooper Farnham's actions. At a certain point, she believed that call less and less. And what I'm saying is when she ultimately, between her ears, and only she will know between her and God, that when she decided to pull them over, she may not have believed the call, but if that was the case, then she needed to follow the 4th Amendment strictly, and she needed independent probable cause to pull them over. Just like the analogy with Scalia in the dissent of Navarrete. When the call was made about somebody transporting marijuana and they showed up and there was no marijuana on the car, well, the tip is now deemed completely unreliable. To me, that's black and white, and that's where officers are trained to do that. Lay people aren't trained to judge whether they're drunk or not. They're just not. We're not tooled in that way. And I am barely tooled as a defense attorney as I learn more and more about breathalyzers and reverse extrapolation and everything that goes into that. But the fact of the matter is, anyone right now can certainly just call 911 and, for lack of better words, swat someone or revenge someone or just call in a license plate number. The recourse is, well, then they maybe if they filed a false police report, there is, if you know the declarant and they decide to lie about the report. But the problem with that is doing a Boolean search under the statute for false police report. There are only 64 cases ever reported in this state about filing false police report. And
I'm sorry, go ahead.
no, I was concluding the truth of the matter, boots on the ground. That's a crime that's almost never charged. There is no recourse for really somebody realistically who is subject to a caller that is wildly inconsistent.
I mean, I'm hearing two different things out of you, because earlier, I thought you were saying there does need to be some traffic infraction. But in answer to Judge Young's question, you're saying the reasonable suspicion is based upon
Well,
was presumed to be, but turned out not to be.
I appreciate the save. I agree with you, Judge. I think following Pagano, which dictates there needs to be some sort of independent crime that's reported. And this is why in Estabrooks, it is fact
Did you just
sensitive.
misspeak? Because in answer to her question, you said that call, they could have pulled him over immediately.
No, I totally misspoke, and I'm not trying to misrepresent my client. I am advocating on what Pagano says in Navarrete to a lesser extent, that you need some sort of independent allegation of a crime. And we live in a world where I could literally pound a drink right now and get in my car
Okay.
right on TV, and it's legal.
But to clarify this, what I said was there's two conclusions in the call, intoxicated and drunk, and then there's the 6 beers. I asked if that was enough to rise to the level of reasonable suspicion, and you said yes if the stop were immediately effectuated. So is the content of the call, no hypotheticals, the literal content of the person's call, ignoring the fact that it all turns out to be wrong, incorrect, lies, whatever. So is that enough to rise to the level of reasonable suspicion? Your answer was yes. Is that not?
I would just qualify it that it should follow Pagano that requires the independent reporting of an actual crime, some sort of road infraction or traffic.
Well, that's my question. Is
And then I'm
is the
clarifying.
caller saying this person's intoxicated, this person's drunk, they're about to operate a motor vehicle, 2 people had 6 beers, or 2 people each had 6 beers, whatever, but 2 people, 6 beers. Is that enough to rise to the level of reasonable suspicion under the law? The content of the phone call that we have in front of us.
Not knowing, because as brother counsel said, we don't have the exact call from 911 to the officer, but under that scenario, I believe the law authorizes an officer to make an investigatory stop.
Right.
But I am advocating that stop should be made immediate because the officer, as he or she exercises discretion, it is a sliding scale. At a certain point, a well-trained officer is going to think, I don't care what I heard from 911. There is no objective evidence of either of these motorcyclists being intoxicated. And at that point, the only way that Trooper Farnham could have pulled over defendant is with an independent corroboration or some other, she touched the fog line, didn't turn on the blinker, had an expired plate, the litany of reasons you can pull someone over. But I understand what you're saying. And frankly, at the end of the day, I think your opinion is going to be addressing that head on. I can advocate that. It would be in bad faith to tell you that the policy considerations on what we try to prevent as crimes to allow people to call in tips is weighed against the idea of a false tip or a swatting or something that can never, toothpaste that can't be put back in the tube. Those are policy considerations at play here. I think what happened in this
Well,
case.
the legal consideration is whether concluding someone's intoxicated and saying 6 beers, 2 people equals unparticularized suspicion or hunch, or if it equals something more than that. It's not so much that we've already concluded it's not false, she's reasonable. We later
Correct.
find out it's false, whatever. But the legal question we have before us is the content of this 911 call the equivalent of an unparticularized suspicion or hunch, or is it the equivalent of reasonable suspicion?
I think that's a different question. I think following Pagano, it's incoherent suspicion. I think it's reckless suspicion by a layperson to draw a conclusion someone's drunk. I don't think anyone is truly absent falling down, throwing up all over themselves. I don't think people are truly in a position to gauge whether or not the amorphous idea of someone may or may not have been drinking. Now suddenly they may or may not be drunk.
Well, she wasn't wrong, was she?
But it's not backward looking.
Okay.
And if we play
But I
that
mean,
way.
you're saying that she's not qualified, all this. She reported what she saw all this, and the spoiler alert is, yeah, I mean, in the end, although that's not really the issue before us
Correct.
either, but in the end, her report was vindicated because he was over the limit, wasn't he?
He was,
Yeah.
but again, we're not backward looking when it comes to the
Right.
exclusionary rule.
But you
At
keep
the
talking about
ends-
how unqualified she is and all this business, but, you know,
But the ends can't
in the
justify the
end.
means. If we
Okay.
open the door to letting anyone just assume someone's drunk, then it becomes a wild goose chase. It really becomes If we call anyone in and then maybe I'm going to hit the lottery, I'm going to find someone who's drunk or someone who has something in their car, contraband. drugs.
Understanding that a layperson probably is not the best judge of whether someone is scientifically over 0.08 or not. What I asked you was, when a layperson concludes, when a layperson calls 911, gives the indication that they're reliable, makes the conclusion that someone is intoxicated, and provides that personal observation of 6 beers, either between 2 people or by 1 person, that's not clear. You said that was reasonable suspicion to effectuate an immediate stop.
I think if we're being genuine to the court under the current status of the law, that officer has the discretion to make an investigatory stop. That I can't argue around that. I can want the law to be different. I can nibble around the corners with Pagano, Navarrete, Richter, and a bunch of other cases. And we can certainly, if we're going to be backward looking, we can see just how unreliable the tipster was. But those are all perils and evils that this court gets to wrestle with ultimately based on both of our arguments here. That if we're going to deputize everyone with a cell phone and the ability to call something in, are there guardrails?
So to Judge Cameron's point, you are here because of the 5-minute delay.
I am here in essence, and I didn't really nail this down in the brief until I started to prepare for the argument, but at that point, I think Trooper Farnham required independent corroboration of the call. I think Trooper Farnham knew as she kept driving that she started questioning that whether or not that call was reliable. And if she herself in her own mind felt that call was unreliable, then on its face, that call is unreliable. So yes, I am here. It's a factual issue as to Ms. Brinkman and the hearsay issues. That's something different. If the case is remanded or if the trial court is upheld, it becomes a bit moot. But at the end of the day, the law exists where people can call in a crime. And I get the policy considerations. We want to create deterrence for crime. We want to enable officers to respond quickly and appropriately. But Farnham's own actions show this court she doubted the call. Otherwise, she would have pulled him over right away.
I think we got any other questions? No. Okay,
Thank you, judges.
Thank you very much. Any rebuttal?
Briefly, I mean, I think with the concession here that the call was reasonable suspicion, I think that this case is effectively resolved here. I think, the standard here is that there has to be reasonable, under Barberich, there has to be sufficient information to identify the vehicle, sufficient information to support an inference that the tipster has witnessed an actual violation that compels an immediate stop. Counsel's conceded there was sufficient information to compel an immediate stop. What he's taking issue with is the settled law in Navarrete that's binding on this court that says 5 minutes isn't enough to dispel reasonable suspicion.
I get what you're saying, but I think we've got this down pretty well.
Thank you.
All right, thank you very much. Any other questions?
I don't have any.
Okay, thank you very much. The matter is submitted. Turning now to item number, interesting case, by the way. Turning now to item number 2, People of the State of Michigan versus Wilson, 369574.
Thank you, Ron. Have a good day.
Yeah, you too.
Good morning. May it please the court. Richard J. Goodman appearing on behalf of the defendant appellant. The court is gracious enough to allow me to appear this morning to answer any questions by the court. Considering all the evidence, I wouldn't be surprised if there aren't any questions, but I welcome the court if they do have.
We don't ask many questions on this panel.
I don't.
Nor do we
myself.
repeat questions.
Mr. Goodman, I, for myself, I don't have any questions.
I don't. You have any?
I don't.
Thank you very much for being here. Thank you.
Good morning, Your Honors. Matt Fillmore from the Oakland County Prosecutor's Office on behalf of the people. I will rest on my brief also, but if the panel has any questions from me, I will try to answer those questions.
I don't.
I don't have any. All right. Thank you both for being here. The matter is submitted. Thank you. You're welcome. Turning now to item number 3, People of the State of Michigan versus Coker, item number 373544.
May it please the court. Good morning, Your Honors. My name is Adam Clements. I'm from Perkins Law Group. I appear on behalf of the defendant appellant in this particular matter, Mr. Robert Coker. Your Honors, I did submit a brief in this particular regard, and anytime I come before for appellate review, and the primary focus of my argument is insufficient evidence or strength of the evidence, I recognize that it puts the defense or puts the appellant in a very difficult position because our jurisprudence requires that we give great deference to the fact finding that and the decisions that have been rendered by a jury. This is something that I didn't articulate in my brief, and I just asked the panel to consider this when you have an opportunity to review the evidence and the sufficiency of the evidence. The defendant, Mr. Coker, in this particular case, there's some dispute about whether or not how fast he was going over the speed limit, but the highest speed limit in question was 66.5 miles per hour. When we think about civil infractions that are varied and that are enumerated with a degree of points for specific traffic infractions, our range highlights points for how severe that traffic infraction is based upon how fast an individual is going. 6 points is what's attributed to reckless driving. In this particular case, if we take the position that Mr. Coker was traveling 66.5 miles per hour on I-696, he'd be going just slightly above the speed limit. He'd be in the range of getting 1 point for an infraction, which would be the lowest civil infraction that could be assessed from a driving perspective. And then,
So his speed alone may or may not be enough. I mean, he's traveling in a construction zone, and for several miles before the accident, there's signs indicating that from the video that the other semi had. It's clear there's traffic stopped in front of him and there's no slowing down. But we also have this testimony about using the phone to take pictures. And the driver himself says, I looked up and it was too late. So there's the admission of not making eye contact with the road in front of you and also using your phone to take photos. Minutes, I think, was the timing, minutes before or a minute before the accident. So even if we accept your argument that the speed alone is not enough to support a reckless driving conviction, there are other behaviors. There's the context of the traffic, and then there's the individual behaviors of the driver that we also have.
certainly, and I would most certainly agree with that, Justice Young. And what I would say in response to that is getting to the next point in position of my argument in terms of there being a combination of civil infractions. The penalties for distracted driving pursuant to our traffic code would be that a first violation will result in a $100 fine, a civil infraction, and community service.
Yeah, but if your distraction rises to the level of recklessness and you kill someone, that's why he's here. So as interesting as it is to think about this in terms of points, we have to take everything in the context. So 2 people died because he rear-ended them at 66 miles an hour. Does his driving rise to the level of recklessness? Well, he was going 66 when everyone else in front of him was stopped. It's a construction zone, and he was taking pictures on his phone a minute before he collided with the car in front of him. That was going 7 and then almost 0 before the collision.
And in response to that, I would say that essentially would take the position that the result of the driving would then justify how we should view it in terms of the degrees of recklessness, because it would be unreasonable for a person to say, because you're traveling 6 miles an hour above the speed limit and that an accident occurs, that necessarily mandates that we take the view that your driving of the motor vehicle was in fact reckless. So I guess what I'm saying, Your Honor, is that when we evaluate typically when we evaluate cases on the criminal defense side, when we assess whether or not an individual is driving recklessly, we don't start with the result of the driving, but rather we look at the actual driving. So again, taking into context or the position that I'm in as the appellant in this particular matter is I'm making a sufficiency of the evidence argument. I'm not focused so much on the end result, but rather on the driving itself, particularly.
Are we able to consider what he was driving? I mean, how much did his rig weigh? It's not like this is a Volkswagen Bug or something that smashed in the back of him.
And
This is a gigantic vehicle, right?
It is. And what I would say to that, and it's something that I thought about arguing when you read the entire balance of the transcript, it's something that Mr. DeSantis argued, and I think it was a powerful argument for the prosecution, is that he indicated that when you drive a truck, you're held to a higher standard. And I think that that's something that maybe a reasonable person could potentially make that assessment, but there's no law, there's no case law that says that. There's nothing from a mandated perspective, but we adjust speed limits for truck drivers, for semi trucks, when they're operating a motor vehicle in a specific area, in a specific
And they're
position.
not allowed to talk on the phone too, right? Are federal regulations, if I recall from my.
They are allowed to talk on the phone if they're utilizing a hands-free.
And this wasn't hands-free, it is taking photos.
Well,
Yeah.
I would submit that there was a conclusion that was made from Specialist Lindstrom in that regard, but there was very limited evidence from the trial transcript to conclude how the photograph was taken, whether or not it was a screenshot. But I think that one could juxtapose that perhaps he was, when he admits by his own admission that he had taken his eye off the road. So I would submit that to that extent that that may suggest that from a photograph perspective in terms of how he operated the device, that perhaps he wasn't utilizing a hands-free, but there's nothing to suggest as it relates to the phone call that he wasn't. And did I answer your question or?
Yes.
Okay. And then the last point that I wanted to kind of address very pointedly, because brother counsel and the response in their question presented indicated that there was improper lane use on behalf of Mr. Coker, indicating that he was in the left passing lane at the time of the collision. Now, perhaps I've watched this video over and over again. There's a truck not a semi truck, but a regular motor vehicle truck positioned in the left lane of Mr. Coker's semi at the time of the collision. From my perspective, he's in the middle lane of 3 lanes at the time of collision. So I don't believe that there's improper lane use. And I think that that's important, again, because it goes back to really the only argument that I can make on behalf of Mr. Coker in this particular regard is that the essence of how he's operating the motor vehicle does not necessarily demonstrate a willful and wanton disregard. We change the way that we view the situation because, unfortunately, in this particular regard, due to his negligence, people lost their lives. But if you were to say that an individual momentarily took their eyes off the road and sent a text or sent a picture and they were going slightly above the speed limit, you would not call that driving reckless. But we're calling it driving reckless here.
Some people would. I might.
I would, okay. And then I would say, I would just think about that from my perspective is in terms of, again, I would go back to what I started my argument with in terms of the points aspect is that 2 civil infractions that are both low level, that are only going to result in 1 point at most. When our point system goes from 1 to 6 for driving offenses, I struggle with being able to reach that conclusion as demonstrating willful and wanton disregard, knowing that our motor vehicle code calls for 6 points for reckless driving when the actual driving in this particular case demonstrated by Mr. Coker at worst would be a 1 point offense. With that, I would yield any other argument at this time. Thank you.
Thank you.
Morning again, Your Honors. Matt Fillmore, Oakland County Prosecutor's Office on behalf of the people. I want to notify the court there are observers in the courtroom on behalf of the victims, Patrick and Barbara Kowalski.
Did you say family members? Or did you say
People close to the
Okay.
victims. Yes.
I misunderstood you. Go ahead. Thank you.
So as the court knows, the evidence has to be viewed in a light most favorable to the prosecution. And as Judge Young pointed out, there's many factors in this case besides just the speed limit that show that defendant was driving recklessly. He wasn't just driving 66 miles per hour on a normal basis. He was driving 66 miles per hour when the accident occurred. When he hit the victim's car from behind, they were going only 7 miles per hour. So obviously, he wasn't looking where he was going. He drove into a construction zone. There were several signs saying construction zone ahead. There's another sign saying you are now entering a construction zone. Speed limit is reduced. He drove over 3 separate sets of rumble strips, which would have alerted him that he's coming into a construction zone and needs to slow down. The speed limit was reduced. And in the meantime, he's driving over the speed limit. He's talking on the phone. He's taking pictures. We have the pictures that he took. He took a picture less than 1 minute before the collision. It's pretty clear he was taking a picture at the time of the collision because he didn't even hit the brakes at all at the time of the collision. Just plowed right into the back of the car without braking. And he admitted that when he looked up, the traffic was stopped. Well, so obviously he was looking down. Yeah, he should have been aware that going into construction zone, traffic might slow down. He wasn't paying attention. So viewing all of those facts together in a light most favorable to the prosecution, the jury could reasonably conclude that defendant was acting with a willful or wanton disregard for safety of property or persons. If the court has any questions, I'll try to answer those questions.
I don't see any.
I
Thank
don't
you.
have any. Thank
Thank you.
you.
Just very briefly, obviously, that was a brief argument and counsel did a great job on his brief. I just would also ask that I wanted to recognize, and I neglected to do this, that my client's entire extended family is immediately behind me in the courtroom as well. And the last thing that I'll say on this particular case is that we have moving violation causing death. And I recognize that that is not a lesser. And I learned that when I first got hired by the Coker family. One of the first points that I wanted to make is that Mr. Sabota was negligent. He failed to ask for a moving violation causing death. And then I researched the law and realized that it's not applicable. But nonetheless, when the standards created that rigidly, we're asking normal lay citizens to make a very tough decision in terms of how we arrive at what constitutes recklessness and what doesn't. With that, I would yield at this particular time. Look forward to, unless there are any other questions, of course.
I don't see any. All
I don't
set.
have any.
All right,
Thank you.
Thank you.
You had a tough case, but I appreciate your argument. I think you've done as well a job as could be made on your client's behalf.
Thank you.
All right, that matter is submitted. Turning now to item number 4, People of the State of Michigan versus Jordan. That's item number 366443. Mr. Tomac.
Good morning, judges. My name is Robert Tomac. I represent the appellant Tukwila Mylan Jordan. Ms. Jordan is appealing her prison sentence of 35 to 60 years. Our claim is that that sentence is excessive and disproportionate and accentuates or gives more weight or disproportionate weight to the goal, that specific goal of punishment. Now, the obvious, what stands out in this case, the first thing that stands out, or the major thing, is the egregious behavior of Miss Jordan prior to the assault. It was abhorrent, and when you look at the circumstance that initially the people were willing to accept a 10-year sentence plus 2 for the mandatory, and then you consider the testimony of the victim, which was very compelling and just painted a unbelievably horrible situation. And the fact that she was already subject to a 25-year minimum under 769.13, I think it's reasonable to argue that she was excessively punished, that she was given this extra 10 years over the 25 mandatory because of her behavior prior to the assault. Now, I understand that the sentencing judge touched on all of the goals of sentencing, the rehabilitation, the protection of society, and so forth, and checked all the boxes. But I have to argue in this case that it seems that there was a undue attention given to the goal of punishment, and so that's essentially the argument. I want to say, in keeping with what the defense attorney argued at the trial at sentencing, despite what happened here, despite these actions, this and for the benefit of her family who may be watching this, Miss Jordan was not a evil incarnate, as someone may come to that conclusion.
How about at the time she shot this woman? Was she then for those moments?
I'm sorry.
How about at the moment that she, for no reason whatsoever, shot this woman? Was she
Yeah,
evil incarnate during those few moments?
Right. I understand, Judge. And I want, in my reading here, and probably it's too late at this point to make this kind of an argument, but I discovered that there is actually a mental disorder that's called intermittent explosive disorder. It's actually listed in the Diagnostic and Statistical Manual of Mental Disorders, fifth edition. And it describes perfectly where someone loses absolute control for the moment and just is not able to control their actions, similar to a road rage kind of situation. So, granted, in that moment, she was not a good person. She was not her normal self. And so in looking at this case and deciding whether or not there was overemphasis on punishment, I would ask the court to be aware of that circumstance that may have had a play in interactions. And so that's the argument I have to present. I do want to mention Judge Ackerman's order. Apparently, my client filed a motion for remand, and there was an order issued by Judge Ackerman. The motion had to do with ineffective assistance of counsel. And I've talked at length with the trial attorney. He did say, the judge, that the request for remand remains for this panel to consider. So that's the extent of our argument, judges.
Okay, thank you very much. Thank you. That matter is submitted. Turning now to item number 5, People of the State of Michigan versus Carswell, 372718.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Carswell. Mr. Carswell was initially charged with 3 felony counts. That was expanded to 5 counts following preliminary examination. There was a first trial in which the jury was unable to render a verdict. This was the second trial in this matter, and the result was a conviction of 1 count of third-degree CSC and acquittals on the other 5 counts, I believe. My concern is that at the outset of the trial, the judge made clear that each side is 30 minutes to conduct voir dire. He says, you can keep track of your time. I'm keeping track of your time. 30 minutes, no more. And we just don't believe that 30 minutes is sufficient on a CSC 1 case involving 5 counts. Well, not all CSC 1.
Even if we agreed with you, like as a general matter, there's discomfort around, okay, we're setting a time limit, especially in a capital case. I didn't see anything on this record that indicated any kind of constraint from the part. There wasn't a time's up moment or darn, I wish I could have said more. So even if we were to agree at first blush, ooh, that makes us uncomfortable. I just don't see how this reflects any kind of harm.
Well, we don't know that because counsel exhausted all of his peremptory challenges, and he did so on this limited time basis without being able to fully flesh out the possible suitability of jurors for this case. Now, there was, after this statement by the judge, the presiding judge, counsel did appear as though he was about to, or in a process of commenting or objecting or in some way offering some kind of a disagreement with that procedure. And he was interrupted by, I guess, his client, who began to ask something about the sequestration of the officer in charge. So we really don't have what appears to be an objection. Mr. Boffman suggested I'm merely surmising, and that instead of looking at this from an abuse of discretion standard, perhaps there may be just a plain error standard. I would submit that there was an abuse of discretion, and I would submit that the whole purpose of voir dire is to try to find the suitability of 14 potential jurors to hear these charges, these very serious charges, one of which carried up to life in prison. And
Mr. Simon, can I interrupt you? I'm glad you're making this argument, that you're the person making this argument, because you've been around for a long time. The old Frank Murphy, and there were a lot of judges in that building, maybe still are, that wouldn't allow any voir dire at all. I'm wondering how you square your personal experience and practice with a limitation of 30 minutes.
Well, Mr. Boffman, yeah, makes the point that there is no right to voir dire. However, when a judge allows voir dire, I don't think that it should be truncated. It should be limited. Well, in an unreasonable fashion. And thank you for reminding me that I'm now too old to become a judge.
Highly experienced, highly experienced.
We believe that there was an abuse of discretion because allowing the voir dire, but then saying, but you only get 30 minutes, I'm keeping time.
But the 30 minutes came after the judge asked quite a few questions, right?
Well, the judge asked some questions, yes.
I mean, they're preliminary ones that the lawyers would have probably asked had the judge not done it. So at least those preliminary ones are out of the way. So to say it was only 30 minutes, it's a little bit, I don't want to say deceptive, but inaccurate, because they would have taken up the time, as I say, asking those other ones had the judge not done it,
Well,
right?
I don't know that the judge's questions were probing deeply into potential bias or.
Maybe not, but there's a lot of questions the judge asked that the lawyers would have asked had the judge not asked, right? So it was 30 minutes on top of those.
Well, yes, certainly Judge Knapp did ask some questions, and I guess you could say that he relieved counsel of the time it would take to ask those questions. But I think that those are preliminary questions that need to be asked anyway, and so yeah, okay, there was some questioning and there was some answers, but I don't know that there was a whole lot of information gleaned from that, which would still require, I think, more probing concern by counsel, and which was, I think, under the circumstances denied. Certainly, counsel didn't ask for additional peremptory challenges. Counsel didn't ask for more time. But I think once he was out of peremptory challenges, there was pretty much nothing more he could do. I don't think that this was a fair trial. And I think that given the fact that the jury found Mr. Carswell not guilty of first-degree CSC, not guilty of 4 out of the 5 counts, there were certainly room, I think, for improvement. And counsel did a very good job, I think, with the results that he achieved. But we think that perhaps given more opportunity to conduct a more thorough voir dire, the results might have eliminated this appeal entirely. There's also the issue about the Batson challenge, and I'll leave that to the court. That was preserved, and we do believe that the response was not sufficient. And for that reason, we also believe that the jury selection process was unfair.
All right. Any questions? All right. Thank you very much for being here, Mr. Simon. Good to see you again. All right. That matter is submitted. Turning now to item number 6, People of the State of Michigan versus Brown, 370814.
Good morning, Your Honors. May it please the court, Pat Selby on behalf of defendant appellant Demetrius Jamal Brown. It's evident that you have read the briefs and the record, but since that includes the appellant's recently filed brief, I'm sorry, the appellee's recently filed brief, I'd like to start by responding to a few points raised by the people, if I may. I'd like to start, though, by citing a very recent unpublished opinion of another panel of this court that explains the issues here very clearly. It's in People v. George, docket number 372377, and I can file a supplemental pleading if you'd like with this case. But that panel noted that there is a meaningful difference between failing to predict what the court might do and failing to correctly apply known facts to the statutory sentencing framework. And in the appellee's brief, they cite another unpublished case of this court, People v. Jackson, with the idea that it would have required clairvoyance for defense counsel to have gotten this calculation right. But the fact of the matter is, what was at issue here with the offense variables, the preliminary examination had already taken place, and yes, the evidence was expanded upon at trial, but the offense variable and the facts supporting them were in front of defense counsel. In addition, competent trial counsel know the critical aspect of the prior record variables. And here, we don't know exactly how it was that counsel erred so badly, but looking at the Class A offense grid, sentencing grid, the final grid they arrived at was an E3 cell, and the erroneous range that was reported could be in a number of different cells, but the most plausible appears to be the one that a C3, which means that the error was largely in the prior record variable. And Strickland says that when there's a failure to investigate, any decision-making after that by counsel is only as reasonable as the reasons for the failure to investigate. And here, it appears evident that the failure to investigate was understanding Mr. Brown's prior record. So in that regard, that is where trial counsel fell below objective reasonableness. Another point that the appellees make that I'd like to address involves whether Mr. Brown would have taken the offer if he had been presented with the correct calculation. And it is true that he tried to put conditions on accepting the plea offer that the trial court denied. He was seeking release on bond or tether or to a rehabilitation facility, number of troubled issues. But the calculation that he was making, the assessment he was making at that time was he had been offered 5.5 years, and it was the gamble that he was making, in essence, going to trial. It would have appeared to him that he was only risking another little over a year. That 81 months translates to 6 years, 9 months. So the 5.5 years versus a little over 6.5.
But did they agree to the 81 months, or did they agree what the guideline range was? Because, I mean, you're comparing the minimum on the guideline range to the offer, but the range is a range, right?
The range is a range, Your Honor, and I don't disagree with that. It's a very common point of reference, though, not just for defendants in their wishful thinking, which is a plausible thing. The people cited People v. Jackson, as I mentioned, for the clairvoyant reference. But in that case, when the defendant was being presented the plea offer, the trial court judge themselves drew to the defendant's attention, here's your plea offer, and here's the low end of the range. So it's a very common point of focus that low end of the range is what grasps the attention of the defendant. And as I say, beyond the defendant as well. And as far as him being informed of that range, it was mentioned to him, and the trial court even said, look, we can go outside the range. But another important example that People v. Jackson case presents is on the record twice, that defendant was asked, did he understand the full range? Was he confirming that understanding? And was he electing to proceed to trial anyway? And in that case, he was asked to, and he did confirm that he understood the full range. In addition to mentioning that Mr. Brown was not informed that armed robbery was a life offense, there was also never any time on the record that his understanding of that, the the people make the point that it was mentioned in passing at a prior conference. But Mr. Brown was not asked his understanding of any of this. So we don't have the same kind of record that the People v. Jackson case presented. A final point on the appellee's brief, they make the observation that Mr. Brown would not have been able to establish a factual record. And regarding that final plea offer, the larceny from a person and the felony firearm charge. But in fact, from the beginning, from the first interrogation with police, he admitted to taking the cell phone from the complainant. So the larceny for a person, he'd already established that, and he was arrested in possession of a firearm. So the factual basis would not have presented a challenge. So what other questions can I answer for the court?
I just wanted to clarify with the ineffective assistance of counsel argument that was, if I understood your motion to remand correctly, limited to the evidence that came in at trial and the plea negotiation stage, but nothing with respect to sentencing. Is that right?
We did not call for that. That was seemed to be a clear Francisco situation. So no, I did not add the ineffective assistance of counsel to that element. But the as you say, and I would like to renew that motion since it was denied for either motion to remand for application of the Lafleur remedy or a Ginther hearing. And I'd also like to renew the remand for resentencing, especially as that request was joined by the people, that there was acknowledgement of the calculation error in argument 3. So, sir, anything else I can address for the court?
Yeah, I just wanted to talk about the record really quick. So even with the concession as to PRV 5, I read the sentencing transcript as defense counsel conceding there were enough misdemeanor and juvenile adjudications in defendant's record to justify the scoring of PRV 5 at 20. So even though that's incorrect, it feels like barring an ineffective assistance of counsel issue, this issue would be waived on the record that we have before us. Specifically, I forget where it's at in the sentencing.
I understand your point, Your Honor, and that is an omission on my part. My focus was on the PRVs and the math. I'm sorry, I'm an ex-engineer and the math speaks to me, and I missed that.
Okay. Thank you.
Thank you very much.
Okay, thank you. All right, the matter is submitted. Turning now to item number 7, Mascom versus Auto Owners Insurance Company 372827.
Good morning. Andrew Mahavlich appearing on behalf of the plaintiff appellants, Lynn and Roy Maxton. Before I start, Your Honor, I'd like to reserve 5 minutes for rebuttal. This case involves an insurance claim regarding a pipe leak that occurred at the Maxton's home in Grosse Pointe, Michigan, on or about June 1st of 2022. It was discovered that a pipe in a upstairs bathroom had come apart and had leaked down through to the first floor, to the ceiling above the kitchen, and affected a number of areas.
What items do you think are time barred of yours?
The plumbing repair.
And only the plumbing repair?
The focus is on, and the court focused on a June 18th 22 letter. That's it. That letter and case law, in particular the Mount Carmel Hospital versus Allstate case, says that for a denial to be effective, it has to be unequivocal and explicit. And perhaps unintentionally, counsel in their response brief conflates the language in a June 10th, 2023 letter that states that plumbing repair throughout the house should be excluded. That doesn't appear until the June 10th, 2023 letter. That's also accompanied by a payment acknowledging service. When they came on June 13th, after it was reported on June 1st of 2022, very little and that was the only time they came to inspect, auto owners did. There was very little that was known with respect to what damage had occurred. It had obviously been reported immediately, but what they saw was that the second floor bathroom wall had been opened up, and there had been an emergency repair done so that the pipe didn't continue to spew water. At that time, it wasn't known that because this house is an older home in Grosse Pointe, that the sewer systems, that the sanitary systems at the time the house was built, and I learned that that's common among many of these homes in Grosse Pointe, is combined with both the gray water as well as the black water.
Storm and sanitary.
It all goes into one.
Right.
And the result was that you didn't just have sink water or bath water going down, but rather there was feces and urine and the sanitary components.
And your position is those are not time barred.
Those are not time barred because they weren't even known at that time. How could they be time barred with respect to something that wasn't known? The other thing that wasn't known is that there's a comment in the August 18th, 2022 letter that says that it looked like it was livable. On August 26th, a week later, Caitlin Sarah from Auto Owners clarifies that when the repairs are going to be made, that those are considered that the house is not livable, obviously, because everything's going to be torn up. And as a result, clarifies that those living expenses not associated with renovation are in fact covered. It's important that the explicit language of the August 18th letter be reviewed. The court, the policy, and I don't think this dispute tracks the statute, but the policy itself says that there's a 1-year statute of limitations with respect to filing claims from the date of loss. The second sentence, both in the statute as well as in the policy itself, says that that's told until there's a denial. Here, the August 18th, 2022 letter specifically said there was coverage, and specifically said that all coverage associated with the pipe leak was covered. Judge Elder, in this case, focused and her looking at the language from the transcript. Her statement specifically was, and her ruling was, I have defendants provided notice of loss on 6/1/20, actually should be 22, 6/1/22, and the claim formally denied on 8/18/2022. The tolling statute stopped on 8/18/2022.
Swept all your claims into that one letter, which
actually said there was coverage. And then there's a payment afterwards. There's a frustration. There's a public appraiser that's hired, Chuck Sorrell from Experts, Public Appraising. He submits a proof of loss. It's accepted. There's payment, partial payment made, and we're talking back way into 2023. And the claim was filed in October of 2023. All this is still going on with respect to those items. The response is, we'll agree to public appraisal. So how could there be a denial in August of 2022 if they're making partial payment? The Cantina case, specifically relying on Quasar, says that where there's a payment, the issue of coverage is gone. It's contractually, it's in the statute. It's not, it tracks the statute, but in the policy itself and the amendments, it says that you're entitled to public appraisal. It was requested and they acknowledge that it was requested.
Are you entitled to an appraisal for items that the insurance company specifically denies?
No, but we are, with respect to those items that are not denied. You cannot on August 18th, 2022, based on a June 13th.
Let me interrupt you for a minute. So you would be entitled to an appraisal of whether the granite countertop that was replaced or the backsplash or the upper cupboards, you'd be entitled to an appraisal for those items if you disagree with the amount that you paid, the actual cash value. But would you be entitled to an appraisal of resanding the hardwood floors when those were denied?
Yes.
Why?
Because it's part of what was covered.
Well, they never extended coverage to the sanding of the hardwood floors.
The August 18th, quoting from the August 18th, 2022 letter says, we indicated to you that coverage would be allotted for accidental direct damage caused by water, the water and accessing the repair, the source of the leak, but no coverage. This is the only part that says no coverage would be provided for the plumbing repairs itself.
So then the insurance company asked you to provide certain information by a certain date. That information was not provided.
It was provided.
It was provided.
Yes. And in fact,
well, your estimate you're talking about, is that what was provided?
Well, no, proof of loss was provided. Timely.
I understand the proof. So your position is that the insurance company still has never denied those items?
No. In fact,
no, that's not your position, or no, they have not?
They have not, and it is our position that they have not. Instead, and this is the frustration, we're getting nowhere. They acknowledge that we're entitled to coverage. They acknowledge there's public appraisal. We're going on a year's time. We hire somebody, all right, because this process by statute and as a matter of policy isn't supposed to cost the homeowner all this money. There's a public appraisal process that specifically is addressed to make this easy and not costly. They even identify somebody, but Brad Heron at Auto Owners repeatedly at the end of each letter says, well, we agree that you have coverage. We agree that you're entitled to public appraisal, but it's premature and it's premature and it's premature. So a lawsuit was filed for a breach of contract because the policy says you're entitled to a public appraisal. They refuse to go to public appraisal. And that was the basis. Now, the significance of that is that the lawsuit is filed, an answer, an affirmative defense filed. There's no responsive pleading that's a motion. And we go for 6 months. Discovery is done, depositions are scheduled, interrogatories, document requests, all of that. We file a motion to compel public appraisal. And in response, more than 6 months later, for the first time, statute of limitations is raised. Now, we know under MCR 2.116 D2 that's supposed to be raised with the first responsive pleading. End of story. It is not disputed that was not raised with the first responsive pleading. According to the court rule and the case law that has discussed it, with no wiggle room, it's waived, right? So the statute of limitations argument shouldn't even be here. The entirety of the matter should go to public appraisal, which is what we requested. But certainly, if you look at, and again, other than the Mark Carmel Hospital versus Allstate case, explicit and unequivocal, nothing in the August 18th letter, whether dealing with living expenses or whether dealing with the plumbing throughout the house. And that language, again, did not appear until the February 10th, 2023 letter, where it says the determination that there was no coverage for the plumbing throughout the house is based on our investigation, policy identified, and information provided. Counsel, perhaps inadvertently, plugs that language into the August 18th, 2022 letter when it doesn't appear there. The only thing the August 18th, 2022 letter says is we indicated that coverage would be allotted for the accidental direct damage caused by water and accessing the repair to the source of the leak, but no coverage would be provided for the plumbing repair itself. That costs less than $200. It was pipe that separated. Now, the claims, at that point, we don't know what's going to happen when they uncover and they go to repairs that are authorized, because it's the only investigation 2 weeks after it occurred. But when they go in past the emergency repair to seal up and to put the repair in, the code enforcement comes in from the city of from Grosse Pointe Farms, and says, no, code enforcement says that when you go in and you make any kind of repair to the plumbing, you've got to now replace this singular sanitary, what I call black and gray water, and that's perhaps a boating term I'm more familiar with, system, and now you have to separate them. And that is the repair that became necessary. And there's a separate policy provision that wasn't invoked until that was discovered in 2023, that covers code enforcement issues where the system had to be separated in order for the house to be reissued a certificate of occupancy. Again, there's separate policy coverage for that hadn't been invoked because nobody knew about it. Same thing with respect to living expenses. On June 13th, 2022, nobody knew what the repairs were going to be. It was 2 weeks after the accident and only an emergency repair was done. Nobody knew the extent of what would become necessary until much later. In fact, until February of 2023, when it actually the house had been torn up to see the extent of what the damage was, which the August 18, 2022 letter said was covered. So you're under those circumstances, Judge Elder clearly erred by saying that the tolling only extended through 2 weeks after a month after the accident, when the August 18, 2022 letter was issued. When that letter, the only thing it says is no coverage would be provided for the plumbing repair itself. That was a $200 repair. And that same letter says, and I'm repeating myself, it says that coverage in fact would be provided for everything else that occurred with respect to not only accessing the repair, but also with respect to the direct damage the leak caused, which is what the claim was, which is what we asked to go to public appraisal. I just addressed briefly my opposing counsel references to Stony Creek Place versus Berkshire Hathaway case as to the tolling of the provisions, and speaks to whether requesting public appraisal somehow tolls the statute of limitations with respect to a denial. And in that case, they say, well, if there was a direct denial with respect to a claim, and in this case, focus on the August 18, 2022 letter only, you can't save it by making a claim for a public appraisal later. We're not arguing that. We're arguing with respect to the public appraisal for everything not covered by the August 18th letter. And the only thing the August 18th letter is explicit and unequivocal about is plumbing repairs, not code compliance, not living expenses, not anything that wasn't known 2 weeks after the leak occurred. Because how could you deny something when there wasn't even an investigation? And again, I'm repeating myself, but how could you know, other than to say there's coverage for this, how could you know the extent of the damage when auto owners came out once, just once, for about a half an hour to inspect? And that's it, immediately after it occurred, and say, yeah, it's covered, but not the repair itself. And everybody knows that. I mean, if you deal with these policies at all, they all have an exclusion for plumbing. Not what occurs as a result of a plumbing failure, but the plumbing repair itself. And that's it. I think that Judge Elder either misunderstood the statute, misunderstood the policy, and in simply arguing that all the claims were somehow denied and time barred. I would say that Judge Elder did not at all address the contractual claim, the motion to compel public appraisal, and she did not address at all the statute of limitations argument under MCR 2.1162 that it was undisputed that had never been raised in the first responsive pleading and therefore waived. That said, I don't know if anybody has any questions. Any of the
I
panel.
don't see any. No, thank you.
Thank you.
All right, you got plenty of time for rebuttal.
Good morning, Brianna Combs on behalf of defendant Appley Auto Owners. It is our position that the trial court properly dismissed plaintiff's complaint in this case because plaintiffs failed to file this action within the 1-year contractual limitations period under the policy. Plaintiff's policy contained this explicit action against us provision, which said an action must be brought within 1 year after the loss occurs, and the time for commencing an action is told until you notify us of the claim and until we formally deny liability. Plaintiffs notified auto owners of the loss the same day as the loss, June 1st, 2022. After conducting an investigation, auto owners notified plaintiffs in an August 18th, 2022 letter that there was coverage for accidental direct damage, which was the limited damage in the kitchen, the ceiling that had been ripped up, and a few cabinets in the kitchen. And then auto owners formally denied liability for several things as confirmed by the language in the letter, including the undamaged second floor bathroom, for plumbing repairs, for additional living expenses, and for the plumbing throughout the home. This unequivocal denial in the August 18th letter ended the tolling. Plaintiffs thus had until August 18th, 2023 to file their action. Instead, in March 2023, plaintiffs submitted a sworn statement of proof of loss claiming entitlement to things that auto owners had already formally denied. If you look at their proof of loss, they're claiming additional living expenses, the upstairs bathroom and the upstairs shower, and the plumbing. And these are all things that auto owners unequivocally denied in the August 18th letter. Plaintiff's response to auto owners' motion for summary disposition cited no law in support of their argument that their claims are timely. Michigan courts routinely enforce these contractual limitations provisions, as we know, under the Supreme Court's decision in Rory, which is still good law as to insurance contract cases. And it's also well settled in Michigan that an insured has an obligation to read their policy, and if they don't, they're deemed to have the knowledge of what the policy states. This court has also consistently upheld the grant of summary disposition where the limitations period expired before plaintiffs filed their suit. This is confirmed by the cases we cite on page 24 of our brief. And I just want to address some of Brother Counsel's arguments. Brother Counsel argues that the August 18th letter only denied coverage for a single $200 PVC pipe. This is directly contradicted by the August 18th letter. Again, it denied coverage for several things. The letter, and I quote, specifically stated, the determination that there is no coverage for the plumbing throughout the home is based on our investigation, the policy identified and information provided. That's directly stated in the August 18th letter, not the February 2023 letter. It was stated again in the February letter, but it was first stated in the August letter. And it seems that Brother Counsel's argument is that auto owners had to deny plaintiff's entire claim for there to be a formal denial, but that is simply untrue, as this court's several decisions have held, including Brown v. AAA, which we cite in our brief, which says there exists authority to the effect that a formal denial of liability need not necessarily deny all liability. Also instructive is this court's decision in Johnson v. Farm Bureau, which we also cite in our brief, that involved only a partial denial as to fencing materials, and this court still held that that constituted a formal denial and that plaintiffs had 1 year from the time that those fencing materials were denied to bring their action. Also instructive is this court's decision in Robinson, which held that the limitations period is told until the insurer formally denies liability and not at the conclusion of correspondence between the parties. And I think it's significant if you look at the letters that auto owners issued, they all remain consistent with the August 18th letter. So we have the August 18th letter, which denied coverage for additional living expenses, plumbing throughout the home, the plumbing repairs itself, and the second floor bathroom. Then if you go to the February 10th letter, which was issued after that, it says the exact same thing. It denies those same 4 things again. And then there were other letters issued in April, May, and June 2023, and they still remain consistent with auto owners' denial. In fact, the May and June letters specifically refer to the August 18th letter, and I think that's crucial because council was on notice, and the June 28th letter was even addressed directly to council. That letter referenced the August 18th letter, and at that time, council still had 2 months left in the limitations period to bring an action and still did not bring an action, even though auto owners consistently relied on that August 18th letter as its formal denial. As to brother counsel's waiver argument, respectfully, brother counsel is wrong that it is undisputed that the limitations period was never raised. In our affirmative defenses, we explicitly state that plaintiff's action is barred by the policy's conditions precedent and also by the terms and conditions of the policy. And the action against this provision is an explicit condition under the policy. So it's our position that we sufficiently raised that in our affirmative defenses. And I'll also note that there's a distinction between this case and other cases where the statute of limitations may only be stated in a specific statute. The limitations period here was also explicitly stated in plaintiff's policy, which they had an obligation to read. So I think that distinguishes this case a little bit from other cases. And I really think that the Stony Park Place case, which we cite in our brief, is instructive here because plaintiff counsel would like to skip the step of the fact that this action is untimely and go straight to appraisal, but Stony Park Place explicitly says that an insured's demand for appraisal does not toll the time to file an action. So we can't just skip that step and go straight to appraisal and go straight to Cantina when this action is untimely. And I think that's what also distinguishes this case from Cantina is in Cantina, there was no untimely filed action that wasn't at issue in that case. And also there was no agreement to go to appraisal like there is in this case as to the items that are not disputed as to coverage. So I think Cantina is distinguishable and is not determinative here. Does the court have any questions that I can answer?
Not I. I think it's all
No,
laid
thank
out
you.
in the briefs
I don't have
nicely.
Thank you
Yeah.
very much.
Thank you.
Very briefly, if I could. One, the first thing I noticed is there's not, council doesn't address MCR 2.116D2 with respect to the waiver of the statute of limitations argument, if not raised in the first response of pleading. There's no dispute that that didn't happen here. And
Well, I thought counsel directly addressed that by saying that they asserted all the defenses that are within the policy. Statute of limitations is within the policy, ergo it was referenced in the affirmative defenses.
But they don't point to a specific affirmative defense that says that. They make that argument that with respect to the policy provisions that we cited, but we didn't cite the one that they argue with respect to a statute of limitations not brought within a year. That's not raised. I mean, the policy is thick. I mean, to simply say that the affirmative defense is and under MCR 2.116 D2, you have to be specific. Statute of limitations, they say arbitration, they say every boilerplate one that the insurance company, has.
But this isn't a statute of limitations, is it? It's a contractual one.
No, it's actually the argument that was made that pursuant to contract, it was a statute of limitations that the contract had to be made, that the argument had to be made within, that a claim had to be brought within 1 year. If there's a statute of limitations, that limitations is shortened by the contract, but it's still a statute of limitations. The Cantina case, if the August 18th, 2022 letter, as counsel argues, was a denial of all the claims, and that was a finding of Judge Elder, why did they pay? Why do they continue to inspect? Why do they issue the February 20th, 2023 letter? Why do they agree to public appraisal? And why does the August 18th, 2022 letter specifically say there, under this policy, there is coverage for water damage resulting from the leaking pipe, for which an estimate has been written, the time we are waiting for further report, As to affected cabinets, upon receipt, we will update update our estimate. We indicated to you that coverage would be allotted for accidental direct damage caused by the water accessing the repair of the source of the water leak. No coverage for the repair. It says the opposite. It says there is coverage. This isn't an explicit, unequivocal denial. It's the opposite. It's an explicit and unequivocal admission that coverage exists. How could that somehow form the basis of the statute of limitations for making a claim when it's not a denial, whether with respect to the contract or looking at MCL 600.2833, which tracks the language in the amendment to the policy. There's no denial. There's an admission that coverage exists, yet Judge Elder precluded all of our claims, even the ones they aren't contesting and never did. Everything. They wouldn't let anything go to public appraisal. They wouldn't grant our motion to allow. There wasn't some argument made that, okay, the living expenses, maybe that should be reviewed, or maybe that's a fact question. They're nothing. Whole claim gone when it was specifically admitted that there was coverage. The argument had never been raised in everything that was submitted by the public appraiser, and he's a experienced public appraiser, does that. They kept saying that coverage exists, but it's premature. Got a minute left. With that said, I believe that Judge Elder perhaps misconstrued or misread. I think that the August 18th, 2022 letter is explicit. I think that the February 10th, 2023 letter that accompanied partial payment, this matter should have been sent to public appraisal, and we would request that the court rule that way.
All right, thank you.
Thank you.
All right, the matter is submitted. Let's take a quick break. 5 minutes. You. All right, turning to the next case on the docket, Vamera versus Micah Davis, 372918.
Good morning, Robert McClellan. I'm here for appellant Detroit International Holdings and Copperfield Investments. And we are here appealing the court's refusal to allow these defendants to put in a claim for improvements under Michigan Court Rule 3.411. This was a complaint brought by Mr. Vamara to have certain deeds set aside because of fraud and to have them held to be of no import whatsoever and be stricken from the record. And the case came before the judge on a motion for a summary disposition against the defendant, Micah Davis, who had been served but had not filed any answer. So the case came before the judge on the motion for default judgment. The judge took testimony and determined that there was indeed fraud on the deed that went from who supposedly represented himself as Vamari or Turi Vamara.
Yeah, the pleadings, that's being fixed. They had the name backwards, I think.
I have the name that.
So I think we have it correct in the heading of it. Some of the pleadings had it backwards.
Turi Vamara.
Yeah.
The deed from Turi Vamara to Micah Davis was deemed to be a fraudulent deed. And when the judge made that determination at this hearing on his motion for default judgment, he also dismissed my clients Detroit International Holdings and Copperfield Investments and held that over objection that they would not be allowed to put in a claim for improvements.
I mean, there's nothing on the record to support that your clients knew that that original deed you just discussed was fraudulent or anything like that.
Nothing on the record. In that's an issue that would be determined upon remand. I think that would be probably a major, and that's what we're asking this court to make a distinction between claim for title and a claim for improvements. The judge held that because of my client's basis for title was based on a void deed, that they had no claim in the property whatsoever. Therefore, they can leave them to their own devices, but they're not allowed to put in a claim for their improvements. As a matter of fact, the judge made no reference to Michigan Court Rule 3.411 whatsoever, and I think it clearly would apply in this case. This is a case to determine interest in land. The jurisdiction would be 629.32, and the Michigan Court Rule is to apply to any action brought under that section.
Remind me what the rough amount of the improvements.
The amount of the improvements?
Yeah.
Estimated close to 100,000. Yeah. Estimated close to 100,000, but we were not allowed to put in a claim, but
Right.
On remand, that would be the first thing to be done.
So I think your issues are pretty much laid out
I
pretty
think
clearly.
I'm about to say that, and I think I just want to stress or ask the court to make that distinction between a good faith purchaser as to title and somebody who makes a claim for improvements that were made in good faith. Two totally different examinations there.
All right. All right.
In the brief for the appellee, he does cite a case, that Prof case, and I wanted to read that. Where a deed is forged, those innocently acquiring interest under the forged deed are in no better position as to title than if they had purchased with notice. So that's as to title.
Not as to
I don't
fraud,
think
right.
that means that if they made in an honest belief that they had a right to be making these improvements, that they should be precluded because in their chain of title, there was a fraud. I think this case needs to be remanded and with instructions to follow the court rule 3.411. Set a hearing that would, like, I guess maybe reincorporate their finding and give us the 28 days after that, and otherwise follow the court rules. And I'm here for any other questions.
I don't have any.
Don't see any. Thank you.
you.
So could you, are you,
So, yes, we don't have any question.
could you approach? I couldn't. Could you please state your name?
I'm Guy Soho. I'm counsel for Appellee, Vermora Toure. Should
Okay.
the court has any question for?
Yeah, I don't see that you're endorsed. Do we have any questions?
I do not. Thank you
Yes,
for
I'm not
coming.
endorsed, but in case the court has any question for us, that will be order that says I can appear, and if there are any question for
Yeah.
me, I can answer.
Yeah, I don't have any questions, but thank you. All right, matter is submitted. Thank you. Turning now to item number 5, AFJN Holdings LLC versus City of Highland Park.
Good afternoon, judges. Kasim Daklala on behalf of the plaintiff appellant AFJN.
Right?
All right, so under what's called MRTMA, the Michigan Regulation and Taxation of Marijuana Act, the licensed sale of marijuana is lawful in the state in all of its cities. That's under Section 2. Section 4 of MRTMA says that cities may opt out. So the default rule is the sale of marijuana is legal in each of the cities, but cities can opt out. Now, under the Home Rule City Act, Section 117.3K, and also relevant here under Highland Park's City Charter, Section 6-4,
publication of an ordinance is a prerequisite to the effectiveness of an ordinance. Just to be clear, I just want to make sure I've got my notes correct. Am I correct that you have 10 minutes
Yes.
of argument?
I think that is correct.
Okay, go ahead. I just want to make sure we're both on the same page. Go right
Right.
ahead.
So publication is a prerequisite to the effectiveness of an ordinance. So in order for Highland Park to successfully opt out of MRTMA and prohibit marijuana sales within Highland Park, they have to publish an ordinance stating that after following all of the prerequisites to pass the ordinance. Now, in this case, Highland Park attempted to pass an ordinance to prohibit the sale of marijuana in the city. And they failed in several respects to accomplish, as the law requires, strict compliance with the requirements for an effective ordinance to be passed. Namely, they failed to publish the ordinance. Now, the lower court has a record before it wherein the deputy clerk of Highland Park submitted an affidavit that stated that the first publication of the ordinance, indeed the only publication of the ordinance, was in April of 2024. Now, the second reading of the ordinance was August 21st, 2023. By Highland Park City Charter, the publication necessarily had to have occurred within 7 days of that second reading, or by September 5th, 2023.
What about the fact that the language of the new ordinance was in the minutes and then the minutes were published within a week?
Yeah. So case law says that strict compliance is required with each and every single prerequisite that a city council has to follow in order to enact an ordinance. Substantial compliance is not enough.
What
People
case
versus
stands for that?
People versus Poima, which we cited in our brief. It says strict compliance with the requirements of any publication requirement, any prerequisites to enactment is required. Substantial compliance is not enough. So at best, publication, as they want to characterize it, of the meeting minutes of the city council on the website would be substantial compliance. But it's not even that, it's non-compliance, because nowhere in the city charter does it make reference to the meeting minutes acting as a substitute for the language, the actual language of the ordinance as enacted. Beyond that, there's an enumeration requirement. So there's failure of publication, but there's also an enumeration requirement in the city charter. And what that says is that the actual number of the ordinance must be printed on the face of the ordinance that's voted upon before it could be an effective ordinance. And in this case, there was no enumeration. Now, how do we know that? Because although the document that eventually the city provided to the court in the lower court had on its face the ordinance number, we sent a FOIA request to the Cannabis Regulatory Agency for the ordinance as submitted to the Cannabis Regulatory Agency. And what came back from that FOIA request was an unenumerated version of the ordinance. If you want to get into the details, during the lower court case, when we presented this to the court, the PDF document that was provided to us by Highland Park, the metadata of that document shows that it was created in April of 2024, which coincides with the date that was given in the affidavit by the deputy city clerk as to the date of publication on the website. So not only was there no publication, there was no enumeration at the time that the ordinance supposedly came into effect. Absent any prerequisite, there can be no effective ordinance, and there's a multitude of prerequisites that were not met. There simply was non-compliance, and even substantial compliance is not enough. So we didn't have an effective ordinance. Now, that's on the issue of whether there was an ordinance. There clearly wasn't. But if this court is tempted to find that somehow there was substantial compliance and that there was some sort of ordinance, we get into the second issue that Highland Park simply can't overcome, which is the fact that AFJN got a certificate of occupancy before the effective date of the substantially complied ordinance. The earliest effective date would have been September 5th, 2024.
But Highland Park issued a certificate of occupancy to AFJN on August 22nd. So 9 days before the earliest effective date, or I'm sorry, no, 13 days. I'm sorry. So the certificate of occupancy states on its face and in the charter that it records that all of the legal requirements for the particular use for which it's issued have been met. Now, if we look at the case law on this, if we look at Natural, which is one of the cases that we cited, now it's an Eastern District of Michigan case, but in that case in 2022, Judge Kumar found Natural versus Highland Park. She found that substantial reliance on promises that were made by Highland Park that we would issue you a certificate of occupancy was sufficient to create a vested right in a marijuana use. Here, we go several steps past promises. We actually had a certificate of occupancy, which by the charter means that we lawfully can operate whatever that certificate of occupancy says on its face, we can operate, which in this case is a marijuana establishment. So Highland Park attempts an ex post facto criminalization or invalidity of this use by stating that because there was September 5th, there was some ordinance, you have to now look back to August 21st and say that that use is now prohibited. Well, they can't. The best they can do is state that it's a legal, non-conforming use. But that's just a long way to say that that's a vested right that they simply can't eliminate. So any way you look at it, very, very likely we win on this first issue of there just simply isn't a valid ordinance even till today. But if you're tempted to find it, we've got a vested right that they have no answer for. We have the right to open and operate as a marijuana dispensary there under state law. You've got a couple minutes for a rebuttal if you'd like to use it. All right, thank you. You're welcome.
Good afternoon. May it please the court. Catherine Ross on behalf of defendant appellee City of Highland Park. To start, I want to address this publication issue because the ordinance was published in accordance with the city charter by being fully included in the meeting minutes for the August 21st, 2023 meeting where it was adopted and voted on by the city council. Now, it is correct, it did not become effective under the charter until 15 days later. However, it was published within the 7 days of being adopted by the council by being fully included in the minutes. There's nothing in the charter that says that it must be both enumerated and published to be effective. In fact, section 6-4B of the charter states that it shall be published to be effective. There's nothing in there requiring enumeration at that point. This was what was relied upon by the lower court, specifically citing the Protecting Michigan Taxpayers versus Board of State Canvassers case, where the court cannot read a penalty into a law when there is none. And here there's no requirement for enumeration to be effective. Therefore, the fact that it may not have been enumerated at that point does not render it an invalid ordinance. I believe we fully addressed the distinguishment of the Poima, if I'm pronouncing that right, case in our briefing, but I do want to touch upon that because there was a strict compliance issue in that case. And in that case, it was a issue of the city attempting to incorporate the Uniform Traffic Code as part of its city ordinances. And so they tried to adopt it by reference. And that was how they published it, was just by reference, rather than a full printing of the code, which was specifically required. You were not permitted to do a by reference publication. That's not the situation here. We have strict compliance in that there was a full publication of the text in the minutes. As discussed, section 2-2C allows for publication both of ordinances or city council meetings to allow, where it's included, to allow that to satisfy the publication requirement. So we do have a valid published ordinance that was in effect come September 5th, 2023. Now, I want to move on to this certificate of occupancy and vested property right issue, because we don't even need to get to that issue, because this is a regulatory ordinance, not a zoning ordinance. So the non-conforming use doctrine and the vested property issue does not come into play when we have a regulatory, not zoning ordinance. And that is coming from the Heath Township and the Natural Aggregates Court cases that are cited and detailed in our briefing. Here, the city was permitted under MRTMA to adopt an ordinance either regulating the number of marijuana facilities within its boundaries, whether it's putting a limit of 2, 3, 5, anything like that, or to fully regulate and prohibit any facilities. So this is a regulatory ordinance that was given to them by the state under MRTMA. This is not a zoning ordinance. So the vested property interest doesn't even come into play because we never get past that hurdle. Now, I do want to address it because it was raised. Even if this was a zoning ordinance, as the lower court pointed out, there's no issue, there's no non-conforming use doctrine that comes into play, because there was not more than a mere expectation that this certificate of occupancy that was issued would allow them to operate. Because as noted fully in our briefing, there was substantial work still being performed at the property for several months after the certificate was issued. There were numerous follow-up and building inspections for various things such as electrical, mechanical, plumbing, with the final inspection coming in play in March of 2024. So we're talking 7 months after it was issued, if I can do math correctly. And so there's not just substantial reliance on this being issued. There's not more than a mere expectation. This is something where there's still substantial work being performed. The building was could not be fully occupied at the time this initial certificate was issued. Further, the certificate was issued stating that at that time it was in compliance with the zoning and the building code. Now, the zoning was in compliance because it was a commercial building. The regulatory portion of it, not in compliance. But that was not the issue with the certificate of occupancy. Further, even if the certificate was issued, the plaintiff never applied for a business license with the city of Highland Park. And that is required to operate any business, whether it may be a marijuana facility, a bakery, car dealership, whatever it may be. They have to have a license with the city, and that was never obtained. So you can't have an expectation and substantial reliance on a certificate of occupancy when you're not even legally allowed to operate within the city because you haven't obtained the necessary licensure from the city. So we don't even satisfy the non-conforming use doctrine, even if there's potentially may have been a zoning ordinance, which it wasn't. So it's our position that the lower court decision granting summary disposition to defendant should be upheld. The court has any questions?
I don't see any. Nope.
Thank you.
We've got a couple minutes.
Thank you.
Like to address these arguments. So they want to argue that there was publication. However, publication, according to the affidavit that was submitted by their witness, the deputy clerk, did not occur until April 2024. They want to use the posting of the draft meeting minutes as some proxy for publication. The charter simply doesn't allow that. In fact, under the charter, section 6.4 for the city of Highland Park, it says, number one, enumeration is required. And it says, within 7 days after enactment of an ordinance, the same shall be numbered for identification and published. There simply wasn't enumeration, as we just heard the concession of. And beyond that, there simply wasn't publication according to the rules of what it means to publish an ordinance within the city of Highland Park's charter. This proxy argument fails on its face. Now, as it relates to whether this is a zoning ordinance or a regulatory ordinance, it really turns upon simply whether it seeks to prohibit a use or whether it seeks to regulate a use, meaning the manner in which that use is to be conducted. Here, we strictly have a pure prohibition, which makes it a zoning ordinance, which of course means that we have a vested right that comes into play. Now,
Case law is clear on that. I mean, council cited national aggregates. We cite that for the proposition too, but it yields a result that is in our favor, not theirs. It says that the distinctions between zoning and regulatory ordinances have been well defined by Michigan courts. For starters, zoning ordinances regulate land uses, while regulatory ordinances regulate activities. So what we're talking about here is the regulation and elimination of the use of marijuana in the city. It doesn't say that if you have a marijuana dispensary in our city, you have to wear a green t-shirt at all times while you're selling marijuana. It doesn't regulate the activity. It prohibits the use. It's clearly a zoning ordinance. And then they want to argue this substantial reliance rubric and saying that we couldn't have relied because there was maybe this or that change made to the property after the certificate of occupancy was granted. That's irrelevant. It doesn't matter, because all of that consideration is only when you don't have a certificate of occupancy.
Right.
If you're still making the build outs, which it's not relevant here.
All right. Any questions?
No.
All right.
I don't have
Thank you.
any. Thank
Thank
you.
you very much. That matter is submitted. Turning now to item number 10, Cheshire versus Marial, 370662. All right, go right ahead.
Good afternoon, Your Honors. May it please the court, Marcus Evangelista appearing on behalf of the defendant, Elaine Marrero. This is one of those rare cases that involves adverse possession and acquiescence. And we learned these concepts many years ago in law school, but I believe it actually happened in this case.
Frankly, not so rare, these cases. We'd be surprised. We get quite a few of them.
Understood. I know the panel is very thorough in its review, but I'd like to punctuate 5 reversible errors that I'd like you to consider. First, the trial court erroneously concluded that a claim of adverse possession and a claim of acquiescence are mutually exclusive. In the written trial opinion dated April 7 of 2024, page 13, the trial court ruled, and I quote, defendant cannot add the statutory period of acquiescence to the statutory period of adverse possession because they have different elements. The judge basically explained in her opinion that defendant may have established acquiescence from 2004 to 2013. And defendant may have established adverse possession from 2013 to 2020, but since you can't add them together, defendant loses that claim. Respectfully, I think that is a misapplication of the law. I believe you can add those periods together. Acquiescence and adverse possessions are close cousins. They have very similar elements, except that you don't have hostility with acquiescence. Both claims can exist at the same time, especially with fence cases, and that we have a fence case. If you think about it, a neighbor can erect a fence on the line and claim adverse possession with that fence. With the same fence, neighbors can both acquiesce to that same fence and to the boundary line. These claims are not mutually exclusive. Both can be satisfied at the same time, and I think that's what we have here. Secondly, the trial court also misapplied the element of hostility. The trial opinion, page 14 stated, and that's on trial opinion, page 14. We all know that if I put up a fence in someone's yard, I don't have to be hostile or emotionally angry or upset. The act of putting up the fence in and of itself satisfies hostility. It's a claim of right. It's a mark of ownership. However, the trial court misunderstood the element of hostility. For adverse possession, the trial court stated, and I quote, even if Mr. Miller built the fence on the deck in 2004, the evidence established that no one acted hostile to defendant's use. No one acted hostile. I believe that is a mistake of law. Adverse possession does not require a neighbor to act hostile or to get angry or to have an emotional hostility. We don't look to neighbors' feelings or emotions. We look at the type of possession, the hostile act itself. Building the fence per se is by definition a hostile act. It does satisfy adverse possession. Randy Miller testified that he built that fence in 2004. That is the hostile act at issue. And in fact, all the witnesses at trial consistently supported the existence of the same fence, a wooden L-shaped old fence. And there was no evidence to the contrary. Number three, my third point is the trial court also misapplied the law on acquiescence. Trial opinion, page 14, and I quote, even if the court accepts that Mr. Miller built the fence in the deck in 2004, the record reflects that Mr. Kajla objected to the disputed area. In other words, the trial court ruled that the neighbor's objection vitiates or cuts off the claim of acquiescence. Once again, we don't look to neighbors' feelings or emotions or objections as to acquiescence. We need to look at the type of possession. The key question for acquiescence is, did the parties tacitly or passively acquiesce to the fence, to the boundary line? Here, Mr. Kajla tacitly accepted the fence. While it is true that he voiced a concern, but he did nothing to do anything about it. Therefore, he acquiesced as a matter of law. Next owner, Mr. Brochot, he also tacitly accepted the fence. Same exact thing. He voiced his concerns and objection, but he also did nothing. Therefore, that is acquiescence. In other words, leaving the fence where it is, the inaction, the tacit acceptance, the passive compliance, by definition, is acquiescence as a matter of law. The law also requires, as we know, neighbors to take action. We all hear, don't sit on your rights. We heard that in law school. If you sit on your rights, that is acquiescence. The legislature has decided and determined that 15 years is enough time. That's the sense of repose you can have for your property. But if that 15-year period expires, it shifts over to the adverse possessor. The possessor now gets that same sense of repose to those property rights. The fourth point is the trial court committed reversible error by failing to rule on defendant's claim of conversion. Conversion was pled in our counterclaim, paragraph 10C, and it stated under a declaratory action, we hereby request the court to declare plaintiff has wrongfully trespassed, converted, and destroyed defendant's property and award defendant's damages and treble damages. That's the conversion statute. Defendant also raised conversion as an affirmative defense, number 9. Cheshire, the defendant Cheshire, who is still a party in this case, had overwhelming notice of the conversion claim. Conversion was raised at every point of the litigation. At summary disposition, July 14, 2021, there's a transcript on the record about conversion. Joint trial brief, page 7, the conversion statute was referenced. My post-trial brief, page 22, conversion was referenced. At trial, there was substantial conversion, evidence of forcible destruction of property. There's literally a video of Mr. Cheshire burning the fence, ripping it down, tearing out trees. We also have photos and videos, exhibits TT, UU, VV, the police report, exhibit GG, fire report, exhibit HH, the inspection report, exhibit II, and the adjuster report, exhibit JJ, documenting all the damages. In short, it was undisputed that Mr. Cheshire forcibly destroyed the personal properties of and burned the fence and trees of defendant Marrero. It was reversible error not to rule on conversion and damages. And to clarify what the trial court did, the trial court ruled on trespass, acquiescence, and adverse possession, but conversion is a totally separate and distinct claim. Burning someone's property is totally different from where the property line is. It's a totally separate and distinct claim. If we can talk, we can fight about the lot line, But if you go and burn and destroy someone's property, that is a claim, an independent claim in and of itself. The fifth point I'd like to make is, as to conversion, very interesting question. Who is liable for the conversion of damages if you find it appropriate? Is it Mr. Cheshire? Is it Ms. Gappy now? Or is it both? Cheshire is still a named party in this lawsuit, and he did not show up to trial. That's on the record. At trial, Ms. Gappy testified under oath that she is not representing Mr. Cheshire. Trial opinion, page 3. Therefore, I believe that Ms. Marrero, defendant, is entitled to default judgment as a matter of law as to Cheshire. As to conversion, it was pled and never ruled upon. In addition, there's also this peculiar assignment of the litigation. Cheshire assigned the litigation to Ms. Gappy when she brought the property. If you look at paragraph D of the assignment, Cheshire transferred and assigned, quote, the rights, title, interest, and obligations of the litigation. Ms. Gappy received $5,000 consideration for this assignment. I believe this makes Gappy and Cheshire jointly and severally liable for the damages of conversion. Moreover, the assignment did not release or novate or indemnify Mr. Cheshire. Cheshire still has liability. I believe they're both on the hook. I leave that to your discretion. Furthermore, Ms. Gappy can't argue this case both ways. On the one hand, at trial, she said, I'm not representing Mr. Cheshire, but in her, and that's on page 3, but on the other hand, in her cross appeal, she states she prosecuted this case on behalf of herself and Cheshire. Opposing counsel takes contradictory positions. I think that undermines her position. And the sixth point I'd like to make, Ms. Gappy, opposing counsel, claims that she is entitled to attorney fees as a pro se litigant. Here, however, the Michigan Court of Appeals has previously held that pro se litigants are not entitled to attorney fees. There's a case, Jomana v. Gappy, the opposing counsel, docket number 305008, 2012, unpublished opinion. It said Ms. Gappy was not entitled to attorney fees because she was a pro se litigant. Notwithstanding the direct ruling against her, she still brings a claim for attorney fees as a pro se litigant. In conclusion, the trial court, I believe, committed reversible error with the misapplication of the law. The claims of adverse possession and acquiescence they're not mutually exclusive. They could coexist at the same time. An analysis needs to focus on the type of possession. Here it was offense, not on the emotions and feelings and the hostility of the neighbors. We ask for a ruling on conversion and find that Cheshire and Gappy are jointly and severally liable. And we also ask that you affirm the trial court's denial of attorney fees because she is a pro se litigant. I'm available for any questions if you have any. Thank you.
I don't see any.
I don't
Thank
have
you.
any right now.
Thank you. Thank you.
Good afternoon, Your Honors. I'm going to be very, very brief. I think counsel is jumping way ahead to what appears to be damages and forgetting to prove its case. The fact of the matter is, my predecessor, owner Kalai, said he went out there, he saw a couple of things on the boundary line, and he talked to the appellant about it. And he said, I asked him point blank, was there a fence? Because he measured it. He's a builder. So he went out and measured the property line. He said there was no fence in 2013. That breaks any kind of acquiescence, adverse possession, 15-year statutory required period. Similarly, the survey that was performed by Mr. Reichert in 2020, no fence. This is a fence case. My counsel just told you that. In 2020, no fence. In 2013, no fence. 2008 aerial photograph of the property, no fence. Appellant signed a purchase agreement in 2019 trying to buy my property from my predecessor. Didn't carve out anything for what she claims to be already be hers in 2019. There were multiple warranty deeds, didn't carve out anything. There was no exclusivity. There was no change to the landscape performed by the appellant. She testified to that. There was no acquiescence of anything because there was nothing on the property line according to the appellant, from 2000, from the time she purchased the property all the way through 2011. There was no fence when the police were called out. There were panels, according to Reichert, in 2020. So that unless the court has any questions, this is not an adverse possession case. This was a defense to a trespass. And there was just no evidence of cogent proof of adverse possession.
All right, thank you. Now, any questions? Thank you. Any quick rebuttal? All right, thank you both very much. That matter is submitted. Turning now to item number 11, people of the state of Michigan versus Philip Edwards, yeah. Well, we just submitted the case.
That's fine. I'm good with that. You can rely on my briefs.
Yep. All right. Thank you. That's item number 371610. No one is endorsed. That matter is submitted on briefs. Next case, item number 12, Tuttleman versus Kempen. That's item number 375646. I don't see anyone endorsed. That matter is submitted on the briefs. Next item, item number 13, In Re William Dennis Souders, 374930. No one is endorsed. That matter is submitted on the briefs. That concludes our cases today. Thank you all. Sir, could you approach just right to the
I'm William Souders.
I'm sorry, you who?
William Souders. I'm here for the matter of William Dennis Souders.
Oh, item number 13?
Yes, sir.
Okay, I don't have anyone endorsed. Are you familiar? You know what that means?
No, sir.
Okay, that means so you're Mr. William Dennis Sowers, is that right?
I'm here for that matter, yes.
Okay.
I'm William Dennis, but.
Yeah, we don't
that
have you
name is-
endorsed, meaning we don't have you indicated as having a right for oral argument, but I'm glad you're here. I'm going to turn to my colleagues, find out if they have any questions
Yes, sir,
for
I'm
you.
available.
Do either of you have any questions?
I don't. I read your brief and I think I understand the issue, but I don't have any questions about it.
That's
Yeah.
the same for me. I
I
don't
just
have any
wanted to
questions.
make myself available just in case.
No, I appreciate that. Thank you
Thank
very
you.
much. I'm sorry I ran right through that, and
No,
I'm
no,
glad
that's
you were assertive enough to let us know you were here. So thank you.
Thank you. Have a good day.
You too. All right. Thank you all very much. That concludes the docket for today.